Good afternoon, everyone. I think we've gotten over what was possibly a little false start. Tracy's in charge of the IT this afternoon, so forgive us. Welcome all to our second COVID webinar dealing with topics this afternoon. Firstly, Neville John is going to give us a presentation on COVID ramifications from a workplace sense in relation to the current issue around compulsory vaccination, some issues about work health and safety, industrial ramifications, particularly now that we're in that phase where we're having to deal with mandated vaccinations, some workers' compensation aspects, of course, where people might, in relation to the vaccination or exposure to COVID, obviously contract the condition. What do we do and how do we approach that from a claims management sense? Mel Conroy is then going to address us on the new edition of the Impairment Assessment Guidelines that have been published and which are in play now, albeit they're not, as a matter of practicality, going to actually impact on too many claims at the moment because they only have a prospective effect and not a retrospective effect. I'll then be addressing some of the more recent and interesting tribunal cases, and Susanna Jovanovic will follow up at the end with a quick recitation on a couple of the Supreme Court cases of note. If we do run a little short on time, we will cut the case update a little short, as obviously for most of you, if you're subscribers to our case updates, you'll have seen some of the cases we'll be talking about today already, or we'll read about some of them in the next edition. You can use the chat box to raise questions, of course, with any of the presenters. If there's burning issues, we'll try and deal with them as we go or at the end of each session. And as we get towards the end, if time allows, we'll jump back over some of the other questions that we might not have got to, or alternatively, we'll respond to them in the fullness of time. So with that in place, Neville, I'd invite you to come to the podium and address us on COVID issues.
Thanks, Mark. We'll just try and get things moving. I can't get the slides to move, which doesn't help. Which didn't work before either. Sorry, we had this problem before we started and it was totally fixed, but now it's not. Anyhow, welcome to the anniversary exactly of Pizzagate, where we were all locked down exactly this time last year. So things haven't gone away. In fact, from an employer perspective, the myriad of issues that COVID has given us just continues. And probably the hot topic at the moment will obviously be mandating vaccines and how, as employers, you deal with that and approach it. The key issues, I guess, are if the government has issued a mandate, that makes life so much easier for us as employers. And as we know, currently the Emergency Management Act health directives encompass health workers, aged care workers, the police, allied health workers now, teachers as at yesterday, and anyone actually involved in education, even those visiting schools, including parents, disability services, home care services. I wouldn't be surprised if that list expands gradually, particularly if after 23 November, when as the media states, COVID will attack us and overrun us, that there may be further mandating. But if not, you as the employer may wish to consider whether it is appropriate for your own workplace to ensure and insist upon your employees being vaccinated. So what is the key? The key really is consultation before we start going down the mandatory line. that comes back to work health safety obligations. Really, this is a work health safety matter. As you'll be aware, your obligation as an employer is to provide a safe workplace as far as reasonably practicable. So what we're going to have to look at is what is reasonably practicable, what is perhaps the gold standard for you as an employer, and does that ultimately lead you to mandating vaccines? Employees themselves also have an obligation to ensure their own safety and the safety and welfare of others around them. So we have a double obligation here at play. So with the combination of the government mandating and the general health orders and the Work Health Safety Act, I think we're on a fairly solid ground to look at the issue of mandating. Clearly, there are issues you can look at beyond or before mandating vaccinations, such as looking at the workplace itself. Do you have adequate ventilation? Can you have adequate ventilation? Obviously, some offices can't. Can you have HEPA filters? That's something that could be installed, but then it's maybe an unjustifiable expense. Social distancing only works so far, and it doesn't really work in a confined office space or a large premises where you've got hundreds of people working together. You might be able to, alternate rosters so you don't have as many people, on site at the same time. But again, that comes down to operational requirements. Working from home obviously is the key to keeping people away from others. But I think as most employers are learning, they would rather have their employees back on site if possible. And there's only a certain type of employee that can really work from home productively going forward. The other issue is rapid antigen testing. It's a bit of a catchword at the moment. These are the tests that you can go and buy at Woolworths now or the chemist. They would have to be self-administered. You would not have the right to administer those on your employees. Would they be viable? Again, is something you'd have to consider. They're quite expensive. And from my research, you would probably have to have an employee have 2 to 3 of those a week. They're great for showing whether an employee is infectious as opposed to being positive, which is the standard test will obviously show if you're positive. But the problem with the standard test is that it shows you positive up to 40 days, whereas you're only infectious for about 3 to 4 days at the most. So rats are something of use, but perhaps not universally practicable when looking at your work health safety obligations. So the key will be here to have a policy in place. That policy will need to encompass, do you want to have vaccines mandated? If the answer is yes, why? Justify it with a risk assessment of your workplace and of places where your workers may be attending, and also include in that people that may be attending your workplace. If you're working with vulnerable people, but you're not covered by a government mandate, then it may be quite justifiable to ensure that all of your employees are vaccinated, because you don't know whether, first of all, the clients are, and ultimately you don't want to be infecting your employees, infecting them, and vice versa. And then that potentially relays back to the back office as well, because you might say, well, look, I'm an admin in the office. I don't go out there and deal with vulnerable people. But if the officers that do go out there come back into the office to report and deal with your staff in admin, then the risk obviously of transmission is there anyway. So it may be a matter of just across the board mandating rather than trying to isolate certain employees within the business itself. And certain health orders tend to deal with that. I know I've just dealt with one in Western Australia where their health order is effectively industry-based. So it doesn't matter what you do within that industry. If you're in that industry, you have to be vaccinated or you can't come to work. What do you do if a worker refuses to work with someone who isn't vaccinated? Now, you may not have a mandate at this stage. So I think, given what the Work Health Safety Act says, there would have to be an imminent and immediate risk to the employee that's objecting to justify them refusing to attend work or leaving work because they happen to work beside or with or happen to associate with at some stage during the day an unvaccinated worker. So I think the chances of that employee presenting a solid case that they should not be at work is fairly slim. But again, like we say in the law, it would be a case-by-case basis. So just looking at mandating, you're probably all aware now that the Fair Work Ombudsman has released guidelines, and I stress these are guidelines only. The Ombudsman takes no responsibility whatsoever if we mess it up as employees, as to who they think should be safely mandated to be vaccinated. And you'll see from the slide there that we have Tier 1. These are the real frontline workers, such as border control and health workers, etc. A lot of these people have already been mandated now. So we jump down to Tier 2, where you've got your employees having close contact with vulnerable people, again, more in the health, aged care, disability arenas. Again, I think you'd have a pretty solid case that mandating would be reasonable in those circumstances. Then we get down to Tier 3, which refers to interaction or likely interaction between employees and other people, such as customers, other employees, or in the public in normal course of their employment. Now, this could be retail. It might be, it could stretch as far as just having a workplace where customers attend and there is interaction between those customers and your employees. Save putting a sign up out the front saying, if you're not vaccinated, don't come in, which is legal. You really are trying to manage that potential risk down the track. So I think Tier 3 is where we're going to have the bulk of the disputes. And that's where the law will probably develop. Tier 4 is probably the most problematic, given that if you don't have employees in a face-to-face interaction, they're not dealing with a large number of co-employees and perhaps even working from home, then you're probably going to struggle to mandate vaccines for them. So the catchword for this year is lawful and reasonable direction. Is it a lawful and reasonable direction to require your employees to have the vaccination, be double vaccinated and ultimately triple vaccinated, as is now the recommendation? And that's going to come down to examining on a case-by-case, employer-by-employer basis whether you can justify such a direction. Now, remember, to be lawful and reasonable directive doesn't mean it has to be the law. It just means that it has to be considered lawful. So it's not breaching a contract of employment, it's not breaching an award or enterprise agreement, and it's not breaching any existing legislated law. So it's like having a policy, no earrings to be worn at work in certain circumstances, or no makeup or whatever. That's fine as long as you can justify it as a policy. It doesn't have to be the law. I mean, the law says you can wear what you like. But if it's reasonable for your circumstances, then that justifies a particular direction. Again, we need to consider, obviously, the non-mandated vaccine alternatives, which I've already discussed. If you end up with the conclusion, look, there really aren't enough to protect my workforce, then mandating will probably be the ultimate gold standard. We'll need to look at, what are the relevant public health orders at present? What's the relevant status of COVID at the moment? It may change between now and next week or the week after next. Once the borders open, the risk may increase. certainly the actual cases may increase as well. So you may well have much more justification to be issuing mandates at that time. Importantly, though, you do need to have your policies and procedures in place and consult with your employees before bringing in such a mandate. Consultation is very important. It's a requirement under the Work Health Safety Act. And if you mess up on that, there's a potential that any order or direction may not be considered reasonable, at least at that point in time. You need to look at the feasibility of the business. Can you operate without having a mandate? Will other customers and clients deal with you if you're not mandating? Again, weigh that up to proportionately to how the impact on the employees will be. We know that probably 95% plus of your employees are going to be already vaccinated, or if not, well on their way to be fully vaccinated. Some might be hesitant still. You might have a very small minority that are just totally opposed, and they're the ones we need to deal with on a one-by-one basis if and when they ultimately refuse to be vaccinated. So perhaps we could just jump then to what happens if you do have an employee refusing to take the vaccination or have the vaccination, sorry. Now, there will be some exemptions if they're pregnant. They're probably advised not to have the vaccination at this stage. They may have legitimate health reasons. They may have a religious objection. The religious objection is probably going to be very far and few between. And I'd be very surprised if you get that type of objection of any validity. Being anti-vax is not a religion. So, and being a QAnon member is not a church or whatever. So the medical exemption, though, is valid, and you will need to consider that if someone comes to you and says, okay, I can't be vaccinated because of medical reasons, that's not good enough. They're going to have to actually present you with proof of that. And there is a formal Medicare form that the doctors have to fill out. And there are very, very few and rare exemptions to being vaccinated. So they'll have to be either immunocompromised or they'll have to have evidence of anaphylactic adverse responses to the vaccines. And beyond that, really, there is no exemption unless a doctor considers that they're that severely ill from other ailments or conditions that they should not have the vaccine. So it's going to be a very rare occasion where you actually get presented with a legitimate medical exemption, and it must be in the proper form, not in the form of a letter from a Chinese medical medicine specialist who one woman tried to rely upon in a flu vaccine case, where basically it was just a person at home that happened to practice Chinese medicine but had no medical qualifications whatsoever. So you have someone refusing for non-legitimate or non-accepted reasons, apart from philosophical, then how do you deal with them? Well, you need to, I guess, consider, will they be putting others and themselves at risk by not being vaccinated and being within your workforce? If the answer is yes, you've already made your risk assessment clearly, then you really have to deal with them on an individual basis. You could try to educate them. Some may well come around if they know that the policy says if you're not vaccinated, you just won't be able to perform your job and you won't have one. If in those circumstances, you might want to reiterate that and perhaps give them an opportunity to go home and think about it before they make a definitive decision. But ultimately, if they're going to refuse to comply with a lawful and reasonable direction, then you're going to have to consider whether you can continue their employment or not. because ultimately they will not be able to provide you with their services. They won't be able to perform the inherent requirements of their job. And ultimately they'll just be frustrating their side of the contract. So it won't be just a matter of sending them off on leave without pay. Ultimately, you need to bring an end to their employment at some point. So you may want to set a time frame for them to reconsider their position. And if they stand firm on that, then I think we can reasonably safely terminate their employment. There is some case precedent, not so much not really in the COVID world at the moment, but certainly on influenza cases. And without going into detail of each of those cases, I can say that every single case that an employee has brought on the basis they were terminated because they refused to receive the influenza vaccination, largely because of government mandating. As we know, that's been mandated in healthcare and aged care for some time. They've all lost. And none of them have been able to produce any valid medical reason for not having the influenza vaccine, which we know is only just one jab every year, let alone 3. Likewise, in a mask case, Qantas was successful in terminating a steward that decided that she couldn't or wouldn't wear a mask because she felt anxious doing so. So they offered her a screen type mask instead, like a welding type mask. And again, she refused to wear that. And ultimately it was found that she was unable to perform the inherent requirements of her job, given that she had to deal with in close contact with customers every day. So there is good and solid precedent from the Fair Work Commission and other courts to give us a fairly good guideline as to how the COVID cases that are starting to be brought will be decided ultimately by the courts. And I think absent a really unnecessary mandate, that most employers should be on fairly solid ground. We obviously need to be aware of potential discrimination cases, but again, that's not going to arise if you're operating under a state mandate in any way. And if you're operating under your own mandate, then consideration obviously has to be given to medical and religious reasons. But beyond that, again, you should be on a winning wicket in relation to dealing with an employee that simply refuses. What about new employees? That makes it much easier. You can just, it forms part of your company policy and procedure, and it can form part of their employment contract. So you only engage employees that are vaccinated. If they're not, they can't meet that term of the offer of employment, and you don't employ them. Also be aware that your own customers and clients may require your employees to be vaccinated and won't allow them into their premises if they're not, and they may have to provide proof of that. So that obviously comes back to a commercial and operational factor that needs to form part of your risk assessment and policies, because obviously if you can't send your employees out to various workplaces, then the business you're running may not be able to continue to do so. We've already spoken about the rapid antigen testing. What about proof of vaccination and collecting? If there's a government mandate, you as an employer are required to collect evidence that your employees are vaccinated. If you don't, you're subject to penalties, and so is the employee. So there's no out from that. If it's an employer mandate, then in South Australia, we don't have our own Privacy Act. We have the Commonwealth Privacy Act that we need to abide by, and the privacy principles within that. And they will dictate effectively that you can't collect sensitive information without an employee's consent. I doubt you're going to have too much opposition to collecting such information with those employees that are already vaccinated. Those that are not vaccinated obviously may not even be your employees much longer, but if they refuse to provide you with evidence of vaccination, then I think you're entitled to imply then that they're not. And that's something else that you might want to put in your policy, is that you do require some evidence of the vaccination to be provided. And that can form two manners. You could actually two manners. You could put a requirement that they consent to the collection of the data that goes on their employee file. End of story. Or you might not want to collect the data as such because you don't have a right to collect it without consent. But you can also view and cite the evidence. So there's nothing against the law about citing the evidence, and you could perhaps then make a third-party record of the fact that that Joe Boggs is vaccinated and or is due for vaccination number 2 or 3 whenever. There's nothing illegal about that. It's just the collection and storage of the data. And it's arguable too that forming part of the employment relationship and policies and procedures, that the collection of such data could actually get around the privacy principles in any event, because once it's on the employee file, it's not covered by those principles. And remembering also that if you're a smaller employer with a less than $3 million turnover, the privacy principles won't apply in any event. I think finally, I might just sneak in. Yeah, will. Just want to touch on workers' compensation. I'm not going to go deep diving into this. If a worker gets COVID at work, then clearly it's going to be compensable. If they're in the course of their employment and their employment was a significant contributing cause to it, that in itself obviously throws up a number of issues and factual disputes. With contact tracing, it's going to be a lot easier to establish potentially where an employee has contracted the disease, and if that location is somewhere that forms part of their employment, then it's a fairly easy case to prove. And in any event, I think experience has told us so far that the negative impact of COVID is not overwhelmingly bad, and long-term COVID is something rarer than just a few days of not feeling very well. So the potential liability arising from contracting COVID may not be significant. Having said that, I did put in there, have you got a spare $12 million? Because there is a case from Sydney where a dental equipment supplier who was actually working for his own business, he was a working director, did have a successful claim. He actually died of COVID in America. He was over there for work and contracted COVID in about March of last year. So it was the height of COVID in the USA. It was found that it was work-related, and he spent 3 months in an American hospital and copped an $11 million medical bill from that, and then ultimately died, and was paid out another $800,000 to his estate because of the death. That's a very rare, an unusual case, but just highlighted out of interest sake, really. But also, it does pose some risk to an employer, of course. If you are mandating vaccines and there's adverse effects to those vaccines for an employee, then that I think would be considered a workplace injury, and you may well be liable for that. There is a federal government scheme which is very, very slowly plodding along and hasn't really evolved as yet. It's designed to be dealing with adverse reactions of vaccines, and but it has a threshold, as in you have to actually have a minimum of $5,000 of expenses and a minimum of 1 night in hospital. before you can even invoke the scheme. And at present, so there's two categories, $5,000 to $20,000, and then there's a $20,000 plus category. But looking at the website, all that is happening at the moment is you can register your interest and leave some details as to the adverse reactions, and then they'll get back to you. So they're not actually, the scheme's not really up and running at all yet. But it's something that you might want to refer your employees off to if they do happen to have an adverse reaction and incur significant costs, because that might divert the cost to the Commonwealth instead of you. And finally, clearly potential liabilities arising from workers' comp claims, weekly payments with time lost, medical expenses incurred, possibly lump sum payments down the track if there's any ongoing permanent impairment as a consequence of contracting the disease or having an adverse reaction to an employer mandated vaccine, and hopefully not death claims. I think, and just obviously if an employee has time off from work because of an adverse reaction, again, it will either be sick leave or their own accrued leave, depending on the circumstances in which they actually had the vaccination. And beyond that, I think that's probably all I can say right at the moment, without delving deeply into the cases and more complex matters about individual approaches to mandating, but open for questions if there are any. Do we take questions now? Or? Yep.
We don't have any at the moment.
Okay.
People can, I've sent out a message that says pose a question using the chat function, so if anyone does, I'll put my hand up. But we don't have any at the moment. Do you want to move on? And
Okay. Thank you all.
I'll put my hand up if somebody does.
All right, so now it's my turn to speak. So we're going to delve into the topic of the impairment assessment guidelines, as a revised version of the guidelines was published in accordance with Section 22 of the Act just recently. So after a period of consultation with the stakeholders, Return to Work SAE, the second version was published in the Gazette, which was on the 24th of August. So there are actually 72 proposed changes, and the majority of the changes were mostly for the purpose of providing greater clarity on how to use and apply the guidelines. So we've noticed that there was actually quite a focus on an increase in the requirement for objective evidence to be present before an assessment can be undertaken, to improve that assessment consistency. So as commented on by Return to Work in that initial consultation paper, the majority of the changes were not expected to impact on the average whole person impairment WPI ratings. However, somewhat not unexpected, there was significant media attention and there was feedback provided on the proposed changes. There were concerns raised by workers' representatives, industry bodies, including the Law Society, and there were some genuine concerns that compensation for workers would be reduced and workers would ultimately then be worse off. So the government, taking into account that feedback, they updated the guidelines, and there are now actually some significant protections to maintain workers' choice of assessor, as well as protections to increase transparency in Return to Work's interactions or, with assessors in the course of reviewing reports and for compliance with the guidelines. So we're just going to run through some of those protections. So the first one is that a worker cannot be directed to choose a particular assessor or to conduct the assessment unless the worker is unable or unwilling to do so. An assessor cannot be directed to alter their clinical opinion when their report is being reviewed for compliance with the guidelines. And so that's consistent with some of the recent case law in the cases of Palios and Cordova Canales. The third one being workers and their representatives need to be promptly provided with the copies of the correspondence between Return to Work and the assessor when reviewing the assessor's report for compliance with the guidelines. Arrangements to make payment of an assessor's report fee needs to commence as soon as the assessor's initial report is received. The fifth one, a worker's appointment with an assessor cannot be delayed due to long waiting lists. And lastly, a worker's appointment with an assessor cannot be delayed past 6 weeks unless agreed with the worker. So that, I think, is something that we're currently seeing in that space, trying to get some of those ENT appointments. So a flow-on effect from all this media attention, there's actually been a bill tabled in the Legislative Council, which is the Return to Work Impairment Assessment Guidelines Amendments Bill by Irene Pneumatikos. So the bill actually is seeking to change the way the guidelines are made from being published by the minister as then actually being made as a regulation. So this would change the nature of the guidelines, and they'd actually be open to parliamentary debate and or disallowance instead. So that was currently before Parliament, the House of Assembly, on the 9th of September. So at this stage, it's a watch this space to see what might happen. So at this stage, what we've got, those guidelines are paramount. As they have been gazetted, there'll be no change to the guidelines unless Return to Work are actually directed to make further revisions by the minister, and any other changes is going to be brought about by case law. So today, what am I going to talk about more specifically? We're going to talk about the main changes to the second edition of the guidelines. So that includes clarification on that definition of disregard and disregarded. We're going to touch on the removal of the 1/1/10th deduction for a pre-existing injury, which is applicable for physical and psychological claims. We're going to look at some of the amendments to the provisions regarding contact with an assessor and stipulating that you cannot direct an assessor to change their clinical opinion. Provide some clarity on the issue of the unilateral communication and basically saying that a requestor cannot direct an assessor to alter their medical opinion. And there are some changes in terms of who can assess what injuries and what that might look like. And for example, the removal of the requirement for a surgeon to undertake a PIA assessment for musculoskeletal injuries. So at this point, I just want to point out what's not actually covered by today's presentation or the changes. And that's the area which causes the most concern for the compensating authorities, which is the issue of combination of injuries and Suhaili claims. So if anyone has been watching the Summerfield decision with keen interest, you would know that the High Court has refusal to grant that special leave to return to work as SAET or appeal the decision. There is little that can actually be done at this point to restrict the impact of those sequelae claims. And the guidelines, they do not address this fundamental issue of combination of injuries. And this can actually only be addressed by legislative change to the Act itself. So that issue, of course, arises from the interpretation of Section 2210 of the Act, and namely assessing the degree of permanent impairment for one or more injuries that are arising from the same trauma. So I think later on in the presentation, you'll get a bit more information on this, on the Summerfield decision, but just in short, the judicial interpretation of that phrase has led to more injuries and sequelae claims being combined with that primary injury, and that gives workers the greater potential to achieve that 30% threshold. So I understand that the Minister has already been called upon by entities such as Business SA to work collaboratively to address this issue, because that's going to require legislative amendments to the Act. So some quick operational impacts. So the addition of the guidelines that is applied is dependent on the date of injury for the claim being assessed. So if a current claim, it's the old guidelines, because they're effective to the 23rd of August. And then for any dates of injury post that, so on any date past the 24th of August 2021, that's when you're going to be using the second guidelines, or the second edition, sorry. So as such, there's definitely going to be some lag time for these fully kick in. And yeah, so most common of these might be something like a noise-induced hearing loss claim, where the claim is most made past that the 24th August date, and the deemed date of injury is likely to be after that date also. So now I'm just going to run through some of those, the key changes following on from the chapters of the guidelines. So starting from the introduction all the way through to the end. So chapter 1 being the introduction, there were quite a few changes in here. So namely, consideration of new injuries that are not in the request letter. So there was a change to that clause and saying that the assessor, if in undertaking that assessment, notes that there is an injury that hasn't been raised in that request letter, letter of instruction, whatever you want to call it, they are actually meant to contact the referrer to see if the assessment should continue. So there are some specific obligations then on the assessor as what they need to do, which is like take a history of the injuries and put that in their report. But it's at this stage, the guidelines state that no WPI calculation for any of the injuries or conditions can be made until they have approval from the requester. So that kind of now links us to in Appendix 1, there are some actually additional notes for the requester, so things that you might need to be across, and it details what a requester needs to provide in that letter of instruction on which impairment should be included and which impairment should be excluded. So it's very similar to what we're doing now, but I guess it's just that extra care is going to need to be taken and definitely identifying what injuries are to be assessed in that letter of instruction. So it looks like that this might have kind of the change to this has happened due to the importance of that one assessment rule. So the potential risk with the preclusion of an assessment being able to be undertaken until you provide approval for all the injuries. So there could be a bit of a delay in assessments being provided, or the assessor then saying, oh, well, look, I found this at the assessment, I can't then undertake the examination. And then they defer that assessment. And so then we're extending out our timeframes. So really something that you want to be getting right, hopefully up front in that letter of request. So moving on now, point 2, assessment for terminal conditions. So change to that point of the guideline, they can occur now if the condition is stable. Obviously, there is some guiding criteria around what that actually means. But if there's a physician that considers that treatment is going to be stable in the short to medium term, though that assessment can now proceed, which is currently being covered off in some current case law on Simeon and Southern Cross Care. There's been an alignment of the definition of the stability of injury, looking at, well, when actually does MMI occur? So that addresses what some issues around defining the foreseeable future, and so now aligns that definition of stability with AMA 5 and Mays as well. There's been some change in clarification in regard to the unrelated injuries or conditions. So those clauses provide some guidance on how to assess unrelated injuries, and it takes a bit more of a prescriptive approach. So where there's some objective evidence for an assessment of an unrelated injury or condition, it must be assessed and deducted, regardless of whether the unrelated injury or condition was asymptomatic. So that clause has remained. But for the further one there is, if there is, objective evidence or unrelated pre-existing injury, but it's not complete, it should still be used for deduction now where possible. So a little bit of rewording has occurred there. Now turning to the methodology for deduction for pre-existing impairment. So this was probably one of the biggest hot topics that got a lot of the media attention and has now subsequently been excluded from this version of the guidelines. So in the initially, assessors were given an alternative way to deduct for a pre-existing impairment if there was evidence of a pre-existing condition by making that 1/1/10 of a deduction. That was trying to give them some scope, some ambit to say that if they didn't have a way to make a deduction that fitted within the process for calculation within the guidelines or under AMA 5, that they could make that relevant deduction. So that could arise in cases like with osteoarthritis. Under the first edition of the guidelines, if the evidence didn't meet that strict requirement, they weren't actually able to make that deduction. So it looked like that clause was a bit of a coverall, trying to guide and help assessors there. That process was then adopted from what's currently happening in the compensation schemes in New South Wales, Queensland and Northern Territory. So has been used and is being used. This deduction was also proposed to be for the psych injury, so for your GAPIC assessments, but then in short, it was removed. So that clause there in terms of the methodology for deduction has reverted back to the very similar wording to the original version, which only permits an assessor to deduct a pre-existing unrelated impairment, which is what we just covered off before. So yes, somewhat topical, and obviously has then the feedback created all of the change, and so now it's something that we can't rely on or apply. Turning to the information required for assessments, that is a clause specifically relating for assessors, which actually now gives them access to radiology online. So it says that they are able to access those imaging and reports that way. So there's an absence in the clause though of a mention of any additional consent needing to be provided by the worker. So we'll just have to look at how that kind of is going to play out in operation. Information required for assessments. So that's kind of like what I've already spoken about, what needs to be in the letter, what needs to be out. So basically which impairments should be included, what should be excluded, and which ones need to be combined. So that clause has just been amended to better reflect how the letters of referral need to be drafted, and is ultimately really consistent with our current process anyway. Adjustment due to medication use. So that's just been a little clarification to that one. So it means that if there's impairment due to the side effects of pain medication, which are actually then going to be reversible upon ceasing that medication, therefore that's not considered permanent or MMI, sorry, and that doesn't qualify for an impairment rating. And lastly, under Chapter 1, some compliance issues. So you'll see that I've got unilateral communication highlighted is not permitted. I don't know how much more we can make that a strong point, because in the consultation period, there was attention drawn to the judicial commentary regarding this compliance function. So there were some key decisions in the tribunal. So Fritzich, I don't know if that's how we say it, but that's how I'm going with it today. Canales, Cordova, and Palios. These cases really highlighted, and there was comments that unilateral communication, so communication between one party and the assessor directly, is not permitted, impermissible, don't do it. So this has now been explicitly incorporated into the guidelines. There are a few more changes in regards to compliance. So just quickly, so it's now explicitly states return to work or a self-insurer can obtain independent medical advice as part of the compliance review process. And then if clarification is sought from an assessor, a response is due, is required, within the 5 business days. Not so much change through Chapter 2 and Chapter 3. So Chapter 2, upper extremity. Some new clauses were inserted and amended to provide greater clarity on how to assess the hand and upper extremity. Felt like most of these were all kind of technical style amendments. However, there was a change in regards to the complex regional pain syndrome. So this is one which there's quite a few that we're going to touch upon later as well, that says that there has to be some kind of diagnosis or certain criteria has to be met before an assessment can proceed. So in this case, a diagnosis has to be made prior to the assessment by at least 2 examining specialists. And the provision has varied between the current guidelines and what was actually the second edition. So it actually has to be a fellow of pain medicine, and originally they had suggested a neurologist, but it's been changed to only pain medicine and a rheumatologist. So these changes have also been reflected in Chapter 3, and they're intended to also help to avoid some confusion between what is chronic regional pain and complex regional pain. So as we know, like the permanent impairment assessment for CRIPS can be controversial, and therefore it's useful to have this more restrictive criteria on the issue of diagnosis before an assessment's made. So if there's a proven diagnosis, as you know, this can result in a significant PIA percentage and can look at that reaching that 30% threshold. So also, I said, limiting what specialists can assess certain conditions. It's also changed in regards to other things like spinal tract damage and cauda-equina syndrome, where the workers had that surgery for a musculoskeletal injury. Lower extremity, again, I found that most of those amendments were technical in nature, so nothing really to cover off. So chapter 4 now, the spine, again, mostly technical amendments there. And then, as I already had covered off on, again, that requirement on who can assess a condition. And so in this case, there has to be a neurosurgeon, neurologist, rehab physician, or orthopedic surgeon. Chapter 5, the nervous system. So we had various clauses amended. Again, some of them being technical in nature. There is a requirement for neuropsychological testing to have occurred within the last 12 months before assessing impairment. And there was a new clause inserted for an acquired brain injury. There's also the requirement now for sleep apnea. So that one needs to be confirmed with a sleep study and by a respiratory physician within the past 2 years before assessing impairment. So as you can see, it's definitely a common theme that's coming through, that just putting some limitations on who can assess what type of injuries. So turning to now to chapter 6, chapter 7 and 8, again, lots more of our technical amendments. For the ear, nose and throat, things we have to have a diagnosis of mastication and deglutition by a treating dentist or specialist prior to assessment. Same for our urinary and reproductive system. So we have to have treatment investigation by a urologist, gynecologist. And for chapter 8, assessment of asthma has to have a diagnosis by a respiratory physician first. Chapter 9 for hearing. So this one actually had quite a few changes. This was all brought about by listening to the feedback brought on, I guess, by our assessors to say what they needed. So some technical amendments, but something that you might have been seeing in your report requests at the moment anyway. We've got some new clauses allowed for the SIRA or cortical evoked response audiometry to be requested by the assessor. So we're seeing this a lot now in the current reports that we're getting back, and this technology wasn't in the previous guidelines. And it seems to be that this is needed when the worker's response to that normal testing has proven to be unreliable. Probably one that is quite important is clause 9.16, which requires the assessor to use the audiogram closest to the date of retirement when the worker has retired. So this will help to resolve the issues when they've retired many years ago and there's evidence of an audiogram closer to the date of retirement. But the case law had required the assessor to use a current audiogram. So that clause had been reworded, so taken from into the second edition. And so now it states that regard must be had to any audiograms undertaken post-retirement and prior to the assessment in determining any non-work related component. So this clause has removed the requirement for the requestor to provide clear guidelines to an assessor regarding the assessment of impairment in these cases. We have some new clauses in there. So clauses 9.17 and 9.20, they provide some more technical guidance on how to assess the noise-induced hearing loss. So overall, I think these additions are quite useful as they reduce the ability of a PIA assessor to kind of justify including lower frequencies in the calculation and potentially maybe reduce some of that arguing about which conduction, air conduction or bone conduction should be used and which should be preferred. So I guess that's the intention between some of these changes. So we're hoping to see that maybe this might result in assessors using only the 2000 to 4000 hertz frequencies and hopefully a bit more of consistency between assessors. Overall, in Chapter 9, most of the other clauses remain the same. Chapter 10, visual, and Chapter 10, and Chapter 11 and 12, again, mostly minor technical amendments to those. So turning to Chapter 13, which is skin, so there were various clauses changed to provide some clarity on rating impairments and the use of the Temsky table. So the Temsky table has actually been amended to include the notation on skin assessors only. It's been included to make it clear that the table can be used for assessors accredited and under any other body systems to rate scarring up to 4%. But any scarring ratings, importantly, beyond that 4% must be made by an assessor accredited in skin. I think that that's not likely, would only usually happen to people having a serious kind of injury, and that's, yeah. Cardiovascular system, Chapter 14. Again, one of those where the diagnosis has to be there before the assessment. So diagnosis by a cardiologist. And then importantly, a little case that came out, Dallimore and Return to Work, which looked at the how to apply the guidelines and for pulmonary hypertension. So those clauses have all been amended following that case. So this is something obviously that you don't need to be overly concerned about, but this will apply more for assessors when undertaking those assessments. So we turn now to digestive and psychiatric under 15 and 16. So again, mostly more so some technical amendments. And then onto psychiatric, of course, that ability to remove the 1/1/10 deduction that has been removed. So we turn now to Chapter 17. So that's the assessor selection process. So there were actually a few changes in this one as well. So trying to reduce delayed or multiple assessments. So there is some guidance then if an assessor is credited for all required body systems, they must be used, as opposed to having multiple assessments then with a lead assessor. And the important one, if the wait time for an assessment with the chosen assessor is greater than 6 weeks, and there's an alternative assessor accredited for the same body system, then they must be used. So there's going to be a little bit of, I guess, toing and froing here, because it requires the person requesting the report to compile a list with reference to the factors in order of priority. So the guidelines set out what those factors are that need to be considered, and then that needs to be given to the worker. Then the worker needs to identify off of that list who they would like to undertake their assessment. So if there are no assessors that meet the criteria, the person requesting the report, as I already said, like need to identify the assessors who meet the criteria, and from there that decision will be made. So most importantly then, what's going to happen if a worker declines to choose an assessor or doesn't choose one? So within 10 business days, it says the requester can choose the assessor in consultation with the worker. So I'm not exactly too sure how that's going to play out, because you've already tried to consult with them to choose one, and then they haven't chosen one. The ability for you to choose the assessor, but I guess you can't just do that carte blanche. You still probably have to, I would suggest, let the worker know that you are making this decision and who you are referring to, and keep them informed in part of the process, even if they aren't engaging and responding. So we're looking now at some of the transparency of referral prior to assessment. Again, this is what we are doing now in terms of drafting that letter of instruction, but that person requesting the letter needs to provide 10 business days for the worker to review the referral prior to sending it to the assessor. And in terms of that transparency of referral prior, so the assessments can't be booked until the process is finalised and all supporting documents are added. So I guess it's what it's trying to say is have all your information up front, and you as the requester, you can't delay the booking of an appointment unless it's actually then agreed with the worker. So notes for the requester, for anyone that is actually requesting or writing these letters of instructions. So there it's covering off on what needs to be in that letter. As we've already said, like what is in, what's out, what's unrelated, and what's going to be deducted. And as I just mentioned, that all of the relevant medical and any allied health information needs to be sent with that letter of instruction. And then it would be the obligation for the assessor to be able to access any kind of imaging or any other resources like that online. So in conclusion, I'll just kind of recap on some of the main operational considerations. Basically, it's like the what's in it for me, what is actually going to affect me, how do I apply this? So just the quick takeaways. So they're effective from the 24th of August. We have some specific requirements in what needs to be in the letter of instruction. Sorry, excuse me. So yeah, terminal conditions then can be assessed, and we're going to look at what is MMI in that. No unilateral communications. So workers need to be provided with any correspondence related to the compliance review. Sorry. Yeah, sure. Yeah, well, seemingly I've got a tickle that's not going to go away. So that, yeah, the last few points there, assessor selection process kept within the 6 weeks, and there are timeframes now for workers to choose their assessor. And then, as already spoken about, the last few slides then are just covering off on those, where, in what situations do you need to get a diagnosis required to going through the PIA assessment? So sleep apnea, mastication, deglutition, asthma, complex regional pain syndrome, neuropsych testing, things like that. So now I'd like to hand over to Mark, and he's going to run you through some of the current case law.
Yes, if anyone has questions on the chat box, Tracy will read them out. Are there any? No, everyone's fully informed, obviously. So terrific. So I'm going to deal with some of the more interesting tribunal cases that we've had flowing through in recent months. As you see, we're starting off with the Morris matter. Quite an interesting one on its facts and became quite notorious. Of course, it hit the media. Morris was employed with the Department of Child Protection, had an injury, had an accepted claim, was quite clearly in receipt of weekly payments, but seemed to believe that wasn't enough to supplement her income. So decided that she might traffic drugs. And that, of course, brought her to the attention of the constabulary, and a world of pain ensued for her, as if having the compensable injury wasn't bad enough. As well as then being charged with a multitude of offences, she thought it was a good idea to effectively try and warn off a witness from giving evidence against her. This all came to the attention of her employer, who thought, well, we can't have this. We're going to issue you with a notice under the Act as part of an overall suite of action they took against her, but effectively decided to discontinue the weekly payments on the basis she's a breach of obligation of mutuality because of the conduct undertaken. And remembering, as a background, as a public service, you have obligations in relation to your behaviour because you are a public servant. So eventually the matter came before the tribunal, and what had occurred through the process of the trial and leading up to it was effectively the concession by the employer that the worker was actually totally incapacitated. That became important in the context of the case because it meant that an argument arose that insofar as the worker was accused of a breach of obligation of mutuality, where she was totally incapacitated, did that entitle the employer to discontinue payments? Mutuality, of course, being a concept long considered to more relate to the obligation of an employer to provide suitable duties to a partially incapacitated employee or be required to pay weekly payments. So the worker argued, well, I can't be in breach of obligation of mutuality because I'm totally incapacitated, I'm unfit for work, and therefore shouldn't have my payments discontinued on those grounds. The judge at first instance agreed, and so did the full bench of the tribunal. And despite referencing her behaviour over time as egregious, amongst other things, they said, well, ultimately, yes, in circumstances where a worker is conceded to have been totally incapacitated, then the ability to argue for breach of obligation and mutuality is neutered. They did logically point out that there were possibly other grounds on which the employer should have taken action against the worker under the Act, including for serious and willful misconduct. So unfortunately, in a hindsight kind of sense, that was where the matter went wrong from the get-go, effectively. One of the judges did raise an interesting issue and said there was some discussion in the case about whether the presence of total incapacity might still in effect be a breach of obligation of mutuality. It's just that it doesn't lead to a right to discontinue weekly payments, but they've literally left that for another day. And look, if you're in that same situation moving forward and you can't, say, argue for serious and willful misconduct, but it is a breach of obligation of mutuality, but the worker is totally incapacitated at that time, then maybe if that's the only ground available to you, you've got to cool your heels until the worker actually becomes partially incapacitated and then have a go. Looking at the pre-approval of surgery and the question of what is surgery of itself, we've had a succession of cases over the last couple of months dealing with the broader issue under Section 33 of the pre-approval process, and then what are you pre-approving? The first case is Clark, and Clark was probably the case that I suppose brought together what's expected under Section 33(21) and its associated regulation, and talking about, well, what are you looking for when you come to pre-approve something? And you'll be aware that the regulation sets out a number of provisions about you need medical information from a doctor, identification of the surgery concerned, date of injury, etc. But what they want as to the fact of the surgery of itself, and they described it as cogent, reliable and reasonable evidence that identifies the nature of the surgery, the benefits that the injured worker will obtain from it, the reasons why it might not be undertaken right at the moment, financial considerations or other health issues impacting on the possibility that it might occur, and the likelihood of it being undertaken in the future. And they've said as a guiding point in Clark that the greater the level of specificity about what you're asking to be approved, then the better off you'll be in having a decision made in your favour as a worker in that regard. What the tribunal said is you've got to look at these things holistically. There are those criteria there. They need to be looked at collectively and then an evaluative judgment, they say, made on all of the reasonable and appropriate evidence that there is in play. And then what it really then comes back to is, and this is where we are going to have difficulty, because when you ask the doctor what the likelihood of the surgery occurring is, you'll get people who respond, oh, it's better than 50% chance. Oh, look, it's a high likelihood. Oh, look, I'm not really sure. Yeah, it's a maybe. The guiding criteria is that you've got to make an assessment about whether that surgery has a real and not remote chance or possibility of occurring. And that's your baseline. So as you see from the succession of cases that move forward, and I'll touch on one further down the track, that's your guiding principle when it comes to it. The next case of Cook, the full bench of the tribunal, handing down a decision not long after the Clark decision, effectively adopted what was set out there and agreed that, yes, that is the question. What is the real but not remote chance or possibility of the identified surgery occurring? Sanders was a variation on the theme. Sanders was one where there was a lack of specificity about what the surgery was that was being proposed. And if you go back to some of the very early applications workers were lodging in this regard, you were getting a grab bag of possible surgical options. We're applying for pre-approval for a discectomy, lumbar spinal fusion, this, that, something else. They're all possible. Well, the tribunal has indicated just putting up a wish list of possible surgeries to cover the field, so to speak, is not what the provision is all about. So just simply saying and making an application for, or even just back surgery, is not going to cut the mustard. It is a case that you need to be way more specific than that. Guy, it's an interesting case, perhaps for one little point, and that is a lesson to case managers when they are looking at applications for pre-approval. And the lesson probably is, if it looks like a duck, talks like a duck and walks like a duck, it's a duck. And in this case, the pre-approval application literally missed out on only one particular aspect of it, and that was to do with the date of injury. And the decision maker decided that might have been good enough to ultimately decide to withdraw a previous pre-approval for surgery. The tribunal said, look, holistically, we all know what's going on here, and you could have simply actually made a request for the worker to clarify that little bit of missing information, rather than deciding that was a good enough reason to throw the whole request out. So be mindful. You've got to be pragmatic about this when it comes to assessing what's before you. Obviously, as the tribunal's directed, the more comprehensive the information, the better, but then nitpicking isn't going to get you a great deal further either. Turning over into that question of what is surgery, and as we've seen now over a progression of cases, what we always consider to be surgery and operations and cutting people open and then stitching them up again, putting things in and pulling things out, is a very much, well, if it's not a 20th century concept, it's certainly a 19th century concept. And we're now seeing a lot of requests for surgery and around the question of what's a therapeutic appliance, going well beyond what we might consider to be the classical scenario of implanting a knee, an artificial knee in someone. And of course, what we're leading to is now that modern form of surgery that's now been accepted, which is quite often seen around the whole idea of injecting something into someone's joint, where it has an ameliorative effect on the symptoms, or it might improve the function of the joint for a time. And quite a common example of that is Synvisc, which the tribunal in the full bench decision of Williams confirmed effectively that yes, stuff like Synvic, it also goes by another name, hyaluronic acid injection. So if you're lining up for one of those, good on you. I'm not sure I would, but things of that nature now appear to be well within the category of a form of therapeutic appliance, because the wording is therapeutic appliance, or the words are therapeutic appliance or aid. And what they've done is use that as a holistic context to say, well, obviously we know what an appliance is, but if something aids in the recovery or the management of the condition, then that's going to be good enough. Deputy President Cole in the Williams decision actually disagreed with his other two members of the tribunal. So I do wonder whether it might be a case that might go on appeal. His take on it was that in using that term aid, we were going, and in relation to injections of themselves, he was looking at the phrase in whole and not breaking it down. So he took a different view on how the whole provision ought to be read and applied. Whether that comment and that approach is taken on in that case or in any other future cases, it's a little bit of a watch this space. And then Pritajon is an example of where the whole idea behind having the operative treatment doesn't have to be, or the provision of the therapeutic appliance, or in the case of Synvic aid, doesn't have to be permanent in its effect or its outcome. Pretty John's a situation where the injection concerned was only potentially going to be of effect for 6 to 12 months. Nonetheless, the tribunal said, no, that's okay. That gets you through the door as well. I won't deal in depth with Maisie's case. Obviously, we've all heard and seen so many examples in recent times of serious injury applications and Section 22 combination issues, and whether the taking of pain-killing medication connected back to a knee injury, connected back to an original back injury should be combined. But there are two things coming out of Maisie's case. And if you look at the case and go to paragraph 175 of Judge Rossi's decision, he sets out and in clear language encapsulates the step-through process by which, when a worker seeks an interim assessment for serious injury, what you've got to look at, what you've got to deal with, who has the onus of establishing things. And one of the key important points, of course, overlying all of this is when you're talking about the concept of interim assessment and the 30% threshold, it's not so much that a doctor says, oh, it will absolutely be more than 30%, it will inevitably be more than 30%. That's not quite the test, but it is that it is likely to be more than 30%. So there doesn't have to be a percentage put forward of itself, just that it will likely be more than 30%. The obligation on the injured worker is to establish that on the balance of probabilities. So they're the sort of questions you're going to have to deal with when you get a preliminary assessment, possibly an indicative assessment, and the doctor says, oh, look, it's likely to fall around the 29 to 30% mark. Is that going to be enough? I think we'd submit no. It's got to be more than that. It's got to be likely. Turning to Section 18 and a couple of interesting cases over the last several months, and I'm just checking my time. Susanna, I'm going to eat into your time, I'm afraid, so because we've got to leave where we are here in about 12 minutes, so I'll keep this very, very short. Coleman Sleep is a continuation of an earlier decision of Judge Crawley, and in Coleman Sleep, Judge Rossi talked about the fact that when it comes to a Section 18 application and an outcome, what you are looking at is the question of incapacity for work at the time the application is before the tribunal and the time the decision is made. So in this case, in the earlier case, the argument, oh, well, I once had a claim and I once had an incapacity, therefore Section 18 applies to me forever, was dismissed. The judges said, well, that would just be leaping over all tenets of industrial law to give you a security of tenure over and above what the ordinary industrial laws might be. So that, just in brief, is the effective outcome of that case. There are a lot of other matters discussed by the judge around that whole industrial concept, which are useful to read if you've got the time. McCormack and the ASC is a useful case for those of you who are self-insurers and who are a group of self-insurers, insofar as if your employee who's injured with group member A is not able to be provided with ongoing employment with them, do group members B and C have an obligation under Section 18 of the Act? And in short, the answer in McCormack was no. And then Gaia, a very recent case only handed down in the last week or so, is again an interesting case to read because it talks about how you have to holistically approach Section 18 and all of the things you need to consider in whether a worker is fit for suitable employment or not. The workplace, the worker, their level of capacity, the industrial situation, the work health and safety situation. I mean, if you're overloading other employees who've got a cover for this person, all of those things get discussed around the concept of reasonable practicability. And in this case, it was a health unit within government. There was a possibility the worker could have worked in a larger unit within the area, the health network. But for various reasons, the judge said, no, look, it's actually a bridge too far in some respects to even impose on a larger employer obligations where so many compromises have to be made in relation to the worker, such as long-term training for someone who really wasn't up to it, the impact on other employees, etc. So even in that case where there was a larger employer, they were still, in a sense, not required to meet the obligation to provide suitable employment. So the case is worth a read from that perspective. And as I said, like all of these Section 18 cases, they're all about the holistic approach to the matter, looking at it from a 360-degree angle. Any questions come through on the chat? So either the chat's not working or anyway, we've got a little bit of time left. I'm sure Susanna will whiz through, and I'm suggesting Susanna maybe just to grab bag of one or two of those decisions, and then we will have to wrap it up. If you do have questions afterwards, feel free to put them on the chat line or email us or ring us. Anyway, over to you, Susanna.
All right, I'll try not to bore everybody with all the details regarding the cases that I was intending on summarising today. Let's start with Dallimore and see how we go. With that case, we had the tribunal find that the worker had suffered 29% WPI due to pulmonary hypertension. The Supreme Court made it quite clear that it's not within the full bench or the Supreme Court's jurisdiction to decide the worker's WPI for pulmonary hypertension, but it is within their limited jurisdiction to decide the proper construction of the AMA guides. And in this case, the pulmonary hypertension couldn't be rated under the guides based on the PAP reading. Apart from the importance of obviously having an understanding in terms of the way that the AMA guides work and the way they should be interpreted, something to take from this case is that you should really try and have a medical expert involved in cases that involve complex conditions such as pulmonary hypertension or, for example, an aortic dissection, so that you've got a good understanding of, all the ins and outs of that particular condition and what effects that will have on the worker's case down the track as well. Making our way through the slides. Summerfield, you're all familiar with the facts. It's a classic case of worker having an injury, compensable injury on X date, then due to overcompensating for the opposing limb, perhaps due to medication use or the aftermath of surgery, they end up claiming consequential injuries, which may become compensable. And then later down the track, they want to undergo a Section 22 process and they want to combine all of those injuries. This case, coupled with Preety and Mitchell, put to rest the issue of combination of injuries. It's pretty clear now that impairments from the same injury or cause are to be combined. So the construction of the phrase same injury or cause in Section 22(8)(c) of the Return to Work Act 2014 shouldn't be construed narrowly. Nothing essentially warrants that the word cause should be interpreted to be the equivalent to an event or series of events out of which the worker's injury arises. So from the worker's perspective, if the phrase was to be construed narrowly, it would be extremely difficult for any of them to really achieve seriously injured status. Of course, from the employer's perspective and the claims agent perspective, it's quite frustrating because the consequential injuries are much easier to be pursued in a way because they don't require the test of necessarily having a significant contributing cause. Had a bit of a discussion with Mark today in relation to this, and he put it quite simply as, all they really have to prove is that it's more than an, how did you put it? Insignificant cause. And so that's the common sense approach, Mark's approach. Let's put it that way. Making our way through to the next case of Dolan. This is a case that involved the worker claiming some psych injuries. The employer's position was that any psych injury basically arose from reasonable administrative action taken in a reasonable manner. The trial judge was criticised for not addressing important questions, or at least failing to provide adequate reasons for the finding that the employer's actions in providing formal disciplinary letters to the worker and arranging a meeting with the department officer did not constitute reasonable actions taken in a reasonable manner. So he's arrived at a conclusion, but hasn't really expressed how he's come to that, why he's skimmed over perhaps some things, etc. There are times, of course, where judges can arrive to a finding by not providing perhaps adequate reasons, because it just simply goes without saying. This wasn't one of those cases. The employer was deprived of the possibility of a successful outcome as a result of the trial judge's failure to address the procedural fairness in this matter. So the matter has been remitted back to the tribunal, and we await the outcome of that case. Looking at the case of Don't, this involved 3 workers essentially who sustained compensable injuries. They had an increase in salary and applied for a review of their AWE calculations in accordance with the 2017 Enterprise Agreement. Under the old Act, as you're all aware, the workers were entitled to have annual reviews of their AWEs. So in this matter, these 3 workers, they tried to test the waters by using a backdoor, essentially, under the Return to Work Act, and more specifically, Section 45 1C. 1A, I can't read my own writing, sorry. The Supreme Court held no, you cannot have the AWE rate reviewed unless you are a seriously injured worker. The last case that I'll try to summarise very briefly is the case of Sunman. This is another case that has been remitted for rehearing because we don't understand how the trial judge arrived to the conclusion that the deceased worker died in compensable circumstances, and that therefore the wife and the kids are entitled to compensation. Essentially, what happened was the worker was driving a truck in the course of his employment. Not long after turning his neck, he suffered a stroke, and then 4 days later, he passes away. There was conflicting medical evidence that was presented at trial, indicating, on the one hand, a causal connection. On the other hand, there was an indication that it was no more than a coincidence. So the lesson, I guess, in this case is, don't look at something in isolation, look at the whole picture. And the best way to do this is get the workers' GP notes, get the hospital notes from the get-go, because something could be spontaneous or not. Hopefully I didn't bore you to death, and hopefully you found our presentation today to be somewhat intellectually stimulating. I'll now invite you all to ask us some questions. In the meantime, if you do want to keep up to date with our summaries in terms of recent cases, etc., please check out the link that's on screen at the moment and subscribe to our publications. Otherwise, I will hand back to Mr. Mark Ken.
Fantastic, Susanna. We've come in right on time. The Law Society just about to throw us out, but we'll just manage to get here before the doors shut. So thank you for tuning in this afternoon. Please give us feedback on the presentation, how you thought it went. We'd love to hear your views on it. I know we'd all like to be in person more often with these type of events, but circumstances being what they are, and look, webinars, because we can record them, you can go away and consider them at your leisure. And look, if you've got questions on review of anything we've talked about today, it's a great opportunity to come back and drill down into some of the stuff where we really didn't get the chance to go in depth on some of those issues. Deduction of prior impairments is a great one for a long discussion, things like that. So please feel free to approach us on that score. But in the meantime, thanks for today. Thank you to my fellow presenters. Thanks to occasional barrel girl and today IT guru Tracy. We hope that Yeah, Tracy has just said, for those who can't hear, first time anyone's called her an IT guru. That is overstating it. Anyway, thank you very much, and good evening to you all. Bye.